So again, my name is Ben Harvey. Thank you all for joining. I really appreciate it. If you have any questions before or after this, feel free to get a hold of me. You should have my contact information. If you don't, you can find it on the Missouri Telehealth Network website. Or if not, I'll be sure to I'll give it out to you in some way. We can follow up with Wendy if you registered, and you can get my contact information. So brief background on myself. I was with the Missouri Department of Health and Human Services for 6 years with the Office of Primary Care and Rural Health. And so I have a little bit of background with this stuff, have seen this. I was around when the original idea for telehealth was passed a few years ago, and then kind of what precipitated into this provider bulletin. So let's go ahead and jump in. But first, some disclaimers. One, I don't work for MO HealthNet. It's fantastic. I'm really happy I don't work for MO HealthNet right now. Do not work for MO HealthNet. And I'm not a lawyer. This is not legal advice. I have to say this because I worked with so many attorneys in our Office of General Counsel and the Attorney General's office. But I want to make sure I make that disclaimer. This is not legal advice for your facilities. It's not legal advice for your operations. And I would encourage you to seek that out if you have those questions. But again, I did work with the Department of Health and Senior Services and MO HealthNet for 6 years. And I've completed this, and it has been reviewed with the assistance of the Center for Health Policy here, the other folks in the Missouri Telehealth Network and the University of Missouri, as well as with MO HealthNet. MO HealthNet themselves have seen the information that I've put in the one pager. They had the chance to respond, and they had no substantive changes. They only had grammatical changes. So from their review of this, the assumptions that I have, I would say are sound. Also note too, before we get into this is a MO HealthNet change. This is a Medicaid change. It only affects MO HealthNet patients. It does not affect Medicare patients. Medicare has its own unique requirements relative to telehealth. The rural piece, being in a rural area, is probably the biggest piece of that. This does not change that. It does not change how you would handle private insurance individuals. It just affects MO HealthNet patients. So please keep that in mind. So you're still dealing with, as every piece of the healthcare system is, multiple pieces of administrative rules and regulations. So this is just MO HealthNet. So here we go. So here's the provider bulletin. This is what came out. This is what constitutes the change to telehealth, the way MO HealthNet is going to address telehealth. This came out February 2nd. It was effective February 1st. And so essentially what it did is it says MO HealthNet is no longer going to be following the regulations it has followed for the past 9 years relative to telehealth, which were found in 13 CSR 70-3.190. It will be following two of the revised statutes. So RISMO 191-1145 and RISMO 191-1146. So on the surface, it doesn't look like much, but it constitutes a pretty significant change from my perspective as to what can take place within telehealth. So this is just in brief, this is the previous regulation for telehealth. This is what was included in that. Some of the pieces that were, I think, the two of the biggest pieces, at least, that affected most folks were, one, you couldn't do asynchronous store and forward. It had to be live interactive video, and you had to have your telehealth services approved by the Missouri Telehealth Network. So those were the previous regulations. But before we get into what the changes were, I want to kind of set the table here. I think this is an important piece to understand both now and for the future of telehealth, because I would imagine, as with anything, healthcare is very dynamic and prone to change right now, and it won't stay static for long, would be my guess. So back up just a little bit, just 2 years. So the statutes that MO HealthNet is now shifting towards, 191-1145 and 191-1146, were put into law along with another set of statutes that deal with telehealth via Senate Bill 579 in the 2016 legislative session, something I had an opportunity to participate in and was excited about and saw come around. It actually included language for the Office of Primary Care and Rural Health to be a part of an advisory body for telehealth. And so it set off new direction for MO HealthNet's telehealth operations. It required MO HealthNet to promulgate new rules governing the practice of telehealth. And a small piece here in my slides, brief side note, anything that is law, I have put in Times New Roman font. And I've tried to bold it. I didn't bold this, but that is actual law. The rest of it that's in the regular font, the Arial font, that's my wording. But things that are in Times New Roman and typically bolded are law. So it required MO HealthNet to promulgate new rules governing the practice of telehealth, and it required coverage for asynchronous store and forward and other services not previously covered by MO HealthNet. So it sought really to expand the services and scope of what telehealth could do in the state of Missouri. That was the general idea, especially for folks in rural areas. And that was really a big part of the thrust here for MO Health, for the change. That was the driving force behind the sponsors' desire to have this go forward and become law. So that passed, right? And so, as everyone knows, MO HealthNet's and Medicaid agencies are typically hyper-efficient government agencies. And so right after the bill became law in August 2006, MO HealthNet immediately promulgated its new rules, right? Well, no, of course not. It didn't. It essentially, no rules were promulgated. And again, being there, I remember this time period. No regulations were promulgated from August 2016 through calendar year 2017. Which makes sense because anything that affects health policy or non-political policy, so those things that don't immediately change by executive order when someone new or a new administration comes into the governor's office, those changes are hard to make during transitions, especially gubernatorial transitions. And so it's not too surprising that something didn't immediately take place, at least from my perspective. So that, I think, began to change, or at least it kind of got disrupted a little bit when Representative Jay Barnes filed House Bill 1617 during this current legislative session. He pre-filed it, so December 13th. And he was the sponsor, or one of the co-sponsors of the bill, Senate Bill 5, or the previous language that was put into Senate Bill 579 to change telehealth regulations in the state of Missouri. So the bill that currently exists, it sat in the Senate now. It never made it out of the Senate, never got a vote on the Senate floor. The legislative session is about ready to go away anyhow at the end of this week. So I doubt anything happens with this House bill, but it did pretty effectively. It sought to force the changes that Senate Bill 579 created, that law, created for MO HealthNet's telehealth operations. And it really became pretty harsh. So previously, 2 years ago, they said, okay, MO HealthNet, here's the base. You guys go off and promulgate new regulations. You can have your influence and your stamp on that. In this case, the law said, you shall not promulgate rules or otherwise place restrictions. You will do what we want you to do, we being the legislature. So it was a significant change in tone. And to some degree, I think that change in tone, you can see it fairly publicly here, but I also think it occurred in back channels behind the scenes and with other stakeholders. And so, from my knowledge of the situation, this bill in part is probably how we got back to this. This is how we got the provider bulletin, where MO HealthNet decided to say, we are no longer following our regulations. We are now going to follow the statutes that you passed 2 years ago, the laws you passed 2 years ago. Which is pretty significant. I don't recall ever seeing MO HealthNet or another agency really just say, okay, fine, we're done. Our regulations no longer matter. We'll go back. Things we've been doing for 9 years we'll no longer do. We'll follow what you want us to do, if given the option. So what does the change actually do? All that being said, what does the change actually do? Well, it removes all of the previous regulations around telehealth for MO HealthNet recipients. And those regulations, because of the way the current administration is doing things here in the state of Missouri, I decided to go ahead and tabulate or total up the number of words. Those previous regulations were about 1,900 words long. They were fairly precise, specific. You can see there at the bottom of the slide, you can see where they list out specifically what types of providers can provide telehealth services. So they were very specific. And so it removes all of that. All of this no longer is something that MO HealthNet is following, and it replaces them with this. And we're not going to go through all of this line by line by line, but I'll talk about the impacts and what this does for more of a real world situation. But you see it includes things like asynchronous store and forward. It includes very general terms like healthcare provider. It doesn't define what a healthcare provider is. I'll show you what definition they reference, but it doesn't provide for that in this statute. It's very general, and it replaces them. This is the second one. This is 191.1146, and those two statutes combined are 800 words. So it's fairly condensed before compared to what you had before. So here we go. So who now can provide telehealth? Any licensed healthcare provider, this is the wording of the law, any licensed healthcare provider shall be authorized to provide telehealth services. So my initial question when I see a statement like this is, what's a healthcare provider? What's a licensed healthcare provider? That seems somewhat simple, but it's not always self-evident. So it references this. It points to this statute, RISMO 376-1350, that says a healthcare provider is a healthcare professional, a physician, or any other healthcare practitioner licensed, accredited, or certified by the state of Missouri to perform specified health services consistent with state law. So any licensed healthcare professional, healthcare provider can perform telehealth services. So that opens up things like LPCs, marriage and family therapists, dietitians, even you could suggest as a healthcare professional. So as long as they're performing those services within consistent with their licensure, they are now able to serve MO HealthNet patients through telehealth. So where can it occur? Where can telemedicine occur? Previously, it was defined. The regulations previous to this change in February defined fairly specifically where they could occur. So like a physician's office, it was fairly narrow, hospital. Now it says, based on these statutes, that you can provide them anywhere you would already provide care for in-person services, so long as it doesn't alter the scope of practice of a healthcare provider or fail to meet the standard of care, which is a good caveat. But it really opens things up. Again, these are very general words here. This is a distant site, is a site where a healthcare provider is located, and an originating site is a site where the patient's located. So this can include things like schools. It can include things like the patient's home. It's a significant change. The specificity is really gone here, except for it saying where you would otherwise normally provide care. So it's a big opening. So that being said, again, the caveat too is that this section 191.1145, it shall not be construed to alter the scope of practice of any healthcare provider or to authorize the delivery of healthcare services in a setting or manner otherwise not authorized by the laws of the state. So this is kind of you can do all of this, but don't forget there are other laws, and you can't use this as a wand to wave away anything else. So tongue in cheek, don't gear up to have your social worker provide teleneurology services in Taco Bell. So don't get too far outside of the box here. There still is a thing that there still are laws, obviously, that hem you in and provide some boundaries here. So what about reimbursement? That would be a great question. There isn't much change. The provider bulletin doesn't change much. It says reimbursement is still at parity, and you use the appropriate CPT code for the service, and you use the GT modifier. Telehealth parity payment law, although it doesn't necessarily impact public insurances like MO HealthNet, there already is a law in the books that requires parity in payment for telehealth services compared to in-person services. So a health insurer in the state of Missouri couldn't lowball you just because you're using telehealth services. They have to pay you what they would otherwise pay you if the visit was conducted in person. But the change for me, though, is that it does open up new avenues of reimbursement via telehealth. So things like new provider types, use LCSWs here, and new locations, so schools. So that payment source is there. So here's a way to kind of put this into a real world situation. So here are some of our frequently asked questions, or things that we thought would be good questions to ask, or questions that may frequently be asked by folks looking at this change or dealing with this change. So the first is, and we received these not as much in the last couple of years, but we have, as do I need to be approved by the Missouri Telehealth Network to bill MO HealthNet for healthcare I give through telemedicine? This was previously in the regulations. I don't know how heavy MO HealthNet was on making sure this occurred. Never having dealt with that myself as a healthcare provider. But the answer now is no, you don't. All MO HealthNet providers who give healthcare to a MO HealthNet patient can bill MO HealthNet for care provided via telemedicine. But of course, the care has to be within the scope of the provider's license and has to meet the standard of care. So there is no reason, there is no mechanism, there is no purpose in sending anything to the Missouri Telehealth Network to get it approved before you can provide services to MO HealthNet patients, to your MO HealthNet patients. The next question is, will a telemedicine claim be paid if the MO HealthNet patient was at their home when I gave the healthcare through telemedicine? Yes, according to the standards set forth by the statutes. Now, how Mo HealthNet is actually going to adjudicate this in a real world situation, that I don't know. And that is something that they still will hold, obviously, the authority to make those decisions on. But based on the statutes that they point out, there is no reason why they will not. The assumption is that they will. I don't know if anyone has real world experience with this right now, if they have gotten a claim paid for seeing someone at home. But assumably, or based on the statutes they point to, yes, it will be repaid. Will it be paid if the provider was at home when they gave the healthcare services through telemedicine? So say a psychiatrist has an office, a home office or something like that attached to their home, and they're seeing patients via their computer. Yes, it will. If it otherwise meets the standard of care and the scope of practice, the provider's scope, then yes, it will. Again, you can't, the doors aren't completely open wide. There still is fencing, but there really is not nearly as much fencing now as there used to be. So I think this has some pretty significant opportunities. Thinking about your own practices or your own situations, I think it has some pretty significant opportunities, or presents you with significant opportunities to look at the way you're providing care to Mo HealthNet patients and see if there are different unique ways that you can utilize telehealth, or if you're already utilizing telehealth, continue to utilize, expand, and change how you use telehealth services in your practices. So this is a question that gears more towards the idea of asynchronous store and forward. So if you visit and there's not a live interactive video, you save the video and the physician comes back or the specialist comes back and reviews that later. Will Mo HealthNet pay for this type of care? Yes, this is asynchronous store and forward. The easiest example of this, of course, is a radiologist. So you get an x-ray, you send it to the radiologist. The radiologist doesn't actually see the patient, just reads the scan and then makes the recommendation back. The asynchronous nature of that, and I just saw a presentation actually, just to mention, on asynchronous psychiatry, actually in the state of California. They've gotten some pretty good results. There's no payment for it in the state of California right now. It's all grant funded. But based on the statutes that Mo HealthNet references here, that would be something that Mo HealthNet would pay for here in the state of Missouri, asynchronous store and forward. So just things to keep in mind as you go forward. So a good question now, kind of thinking of the change and having discussed it and kind of look at a little bit of the real world impact of it. And after this, we'll get to questions, but I wanted to at least kind of keep an eye towards the future of this, again, knowing how volatile healthcare can be and how volatile Mo HealthNet can be, at least in general. Is the big question for me is that we talked about this earlier. I had some slides on this earlier. Is that there is another set of statutes. There's another set of statutes in state law that guides or requires different things for Mo HealthNet. So Mo HealthNet chose to reference two statutes, 191, 1145, and 191, 1146. But what about 208, 670, and 686 through 686? On the surface, at least from the way I read these laws are in conflict. And so an example of this conflict, just showing you here, is that 208, 670, and hang on, I'm just going to mute a couple lines here so we don't have the background noise, since I'm in charge of the muting and the unmuting. Okay, so 208, 670 says that reimbursement for the use of asynchronous store and forward is limited to orthopedics, dermatology, ophthalmology, optometry, in the cases of diabetic retinopathy, et cetera, et cetera. So it provides some specific framing for which Mo HealthNet can reimburse asynchronous store and forward. So as far as I know, unless there's something else funny going on here, which I haven't seen, is entirely possible that I haven't seen, and I have no indication that it is, these two laws are in conflict. So why Mo HealthNet chose to reference those two statutes as opposed to this set of statutes, I don't know. I don't know the answer to that question. What resolves that conflict? Again, I don't know. I mean, typically if a state agency is doing something that does not follow state law, it requires someone to go through the court system to change that. Why someone would want to do that in this case, I have no idea. But I at least want folks to know that there is this kind of issue out there. I mean, this isn't, it's not a perfect situation where you just have one pure set of laws and everything's going to be golden from here on out. There is, at least to some degree, from my perspective, there is some conflict. The House bill we talked about that's still current. Again, I haven't seen it attached to any other bills. It may have been. Someone may know that if in fact it happened. I don't think it has. But House Bill 1617 would have alleviated that conflict because it refined and reestablished those laws that were passed 2 years ago. So you could see something like that. The individual sponsor of the bill, Representative Jay Barnes, is term limited this year. And he has a few other things going on right now with the governor. So what will actually happen with this, I don't know. What will happen in the future, I don't know. But at the very least, I want to sum all that up with an eye towards the future to say, using telehealth delivered services to MO HealthNet beneficiaries is significantly less restricted. So take advantage of that. Look at this through a different lens. Change your mindset on how telehealth can be used, especially for Medicaid patients. The Medicare issues, the regulations still exist, but for Medicaid patients, this is a pretty significant change. It's substantial, and recognize again that what you're doing now is substantially different than what you did even 6 months ago as it relates to telehealth. So take advantage. Yeah, and with that, we have time for questions. I'll stop sharing my screen. And if you have any questions, by all means, please feel free to unmute your microphone and ask away. Or chat it in. If you don't have a microphone, by all means, feel free to chat it in.
I have a question. I'm Joanne
Yes.
with Tri-County Mental Health Services.
Yeah.
There has been some discussion in the past that I've heard rumblings about that for telepsychiatry, there is a requirement that there is at least an initial in-person face-to-face visit to be to continue services and to be eligible for billing with MO HealthNet. Is that true?
So again, it not being MO HealthNet, I can't say MO HealthNet says this, but I can say based on the statutes, just having looked at the statutes, that it does not provide, the two statutes that they reference, they do not provide for a constraint like what you just said. Now, if MO HealthNet would say, well, that's not within the scope of practice or that's not standard of care, that could be a way out of that. But as it pertains to telehealth, these two statutes do not provide for something like that to occur. Does that make sense? I know it's not easy.
It totally makes sense, and it's a perfect answer because I wanted some reference point to support what I thought, just from my readings, but that is a reference point that I can use. So thank you very much.
Okay, good. You're welcome. I just saw briefly Melissa Tepe brought up too. This is for community health centers. And I have verified this with the National Association of Community Health Centers. They concurred on my assessment here. For MO HealthNet patients, for Medicaid patients, there is no restriction on community health centers, FQHCs, being the distant site and billing for services. That is a Medicare regulation. It is not set by CMS. It is not set by the state Medicaid agency. So there is no restriction on that. And so there's another question about informed consent. That I don't know if anybody wants to expound on that. Where are we at with informed consent? Is there a conflict between statutes in that area? Not that I'm aware of. I mean, my typical answer with that would be that there would be whatever would be consistent. I mean, most of the answers to these questions would be whatever the standard is for an in-person visit. You would try to emulate that for a telehealth visit. That would be kind of that's what I would consider to be, if I had to choose a bright line rule here, that would be what I would choose. That's how I would handle most of those questions. And no, there's another question about what's the typical method for evidence that the client actually presented for the service. Currently, clients sign in for the service at the brick and mortar. Do you know how MO HealthNet determines this? I don't specifically, but there, again, that clinical documentation, that would be something to work through. And I know there are a number, having seen them myself, there are a number of vendors, there are a number of software systems that are pretty complex and cover telehealth services pretty completely. And I would imagine they have the opportunity or a way to do that, to have that verification if you need that form of verification. So there we go. Okay, so Lindsay Haslog has a question. Sorry, I'm going to echo in that. Can you clarify regarding the billing for originating in distant site? If an organization is contracting for services like behavioral health, does the site where the provider is located bill the services, or the organization, such as an FQHC, where the patient is bill the services? That's a fairly nuanced billing question. I'm not 100% sure. I just know that the limitation on an FQHC being a distant site that exists via Medicare or for Medicare patients does not exist for Medicaid patients. So beyond that, that question, Lindsay, seems a little bit more specific, and I wouldn't want to provide you with a false answer to that. That may be something you want to ask MO HealthNet directly, but at least on the surface, that limitation that an FQHC cannot be a distant site is not a limitation for MO HealthNet. So it still is a limitation for Medicare, but it is not for MO HealthNet, if that makes sense. So yeah, then the next question from Lori. So an FQHC could see a patient from their clinic site and the patient be in a school. Yes, if it meets the standard of care and it's within the scope of practice of the provider, then yes, yes, they could. There is no, on the surface of that, unless there's some conflicting law somewhere else, on the surface of this, no, that's not a problem. So yes, to your question, yes, an FQHC could see a patient from their clinic site and the patient be in a school. Yes, the recording of the presentation will be available. We'll try to get out everyone that registered. We'll get you a link to that, or we'll get it to you somehow. We'll let you know how you can access a recording of the presentation. We'll also let you know how you can access the slides that I've presented here, and again, give you more contact information in case you have any other questions subsequent to that. So the next question, do you have information regarding the new telehealth rule for APRNs and miles between APRNs and their collaborative physician and distance allowed between them? So I've looked at this a little bit. I wouldn't pretend to be an expert in this at all. So the telehealth rule for APRNs and collaborative physicians, the way I understand it is that if they utilize telehealth, the distances are increased and they have to see each other in person less often, obviously because they're using telehealth. So whether or not, how the boards are handling that, the board of nursing, the board of healing arts, I don't know. I haven't really seen anything specifically, but it just in general, I know that it is in existence. And we've had a couple questions about it. I haven't really heard of anybody real world using that, like given like a real world example of it, but we've had a few questions about it. If you have a more specific question or you want to get into it a little bit more, or anything else, by all means, feel free to chat now or ask me later. So here's another question. Are you aware of any particular restriction of nurses calling in orders for medications that come from a telehealth provider? No. That is, again, kind of going back to the idea that if you do it, how you do it or how you handle things in an in-person visit is how you should handle things in a telehealth visit. So if an in-person visit, this kind of looks a little bit different for an in-person visit. But if a nurse, if someone sees a physician in person, that physician's in the office and the nurse is in the office, would the nurse, call in order for medication from the office? It looks a little bit different. I understand that with telehealth, but in general, if that is something that could occur with under the scope of practice of that nurse's license, and that fits in the standard of care, then there would be no particular restriction. Now that doesn't mean, that's why I say with the telehealth regulations and the statutes that I referenced, if the Board of Nursing, if the Board of Healing Arts has something over or within their regulations or their practice acts that restrict this telehealth, the change to telehealth for MO HealthNet, it does not change their scope. It does not alter. It does not remove. It does not change. It does not adjust any of those things. It just essentially says what you are already doing as a licensed provider, any licensed healthcare provider in the state, you can do via telehealth for MO HealthNet recipients. So does MO HealthNet require that providers equipment have the ability to store and forward, or just those places that want to use that technology? Yeah, there is no requirement. There is no technological requirement now. In the past, there were some soft technological requirements, and you had to have those approved by the Missouri Telehealth Network. But now there are no requirements. There is no specific equipment that's required. So you can do, in the case of this question, you can do store and forward. But you don't have to. It can just be live interactive. In fact, a lot of the providers here at the University of Missouri just use what we're using right now, which is a Zoom connection. So you connect with the patient over Zoom. It's an encrypted connection, and you essentially just need the cameras, and you need the laptops, and you need a computer, and you need a screen. So there is no equipment requirement that MO HealthNet places right now. So any other questions, any other thoughts? If not, let me look and make sure again in the chat. Okay. If not, thank you guys for joining me. I appreciate it. I appreciate the opportunity to present in front of you. If you have any questions subsequent to this, if any issues, anything else comes up, by all means, feel free to contact us. Again, we'll get you the recording. We'll get you the slides. We'll get you the one-pager. We'll get you the contact information, and we can all take it from there. So good luck. Thanks again. Please, please, please go ahead and look at telehealth. Look at how you're using telehealth, and take advantage of the newfound freedom.